Okay, so with those new terms in mind, let's go back to the bankruptcy process. The trustee's job is to review your finances, your debts, and your assets, and then identify your non-exempt assets, seize them, sell them, and then distribute the sale proceeds to your unsecured creditors. I just mentioned some terminology there that warrants some additional diving into. So let's pull out the old Venn diagram to do that. Here we have in the rectangle the universe of properties that you own, and the law divides your properties into two groups, namely exempt properties and non-exempt properties. Exempt properties are properties that you get to keep in bankruptcy. By contrast, non-exempt properties are properties that you may lose in bankruptcy. Bear in mind, 96% of debtors do not lose anything in Chapter 7 bankruptcy. Okay, so let's take a deeper dive into these two types of properties. Non-exempt properties are further divided into two groups: secured properties and unsecured properties. So secured properties are related to those secured debts I just mentioned. So these are basically collaterals that are used to guarantee those secured debts. So examples of secured properties are your home or your vehicle or your appliance if you're financing it. So secured properties come in two flavors: those in which you have equity and those in which you don't. So in a Chapter 7 bankruptcy proceeding, you will not lose secured properties in which you have no equity. You will only risk losing secured properties in which you have equity, and also your unsecured properties. All right, let's talk about exempt properties. So like I said, exempt properties are for the most part exempt from liquidation. So you get to keep those properties, but up to a certain value, and that value is what we call an exemption limit. Exemption limits differ from state to state and from property to property. So since I'm located in California, let's take California law as an example to illuminate what exemption means. So in California, a Chapter 7 debtor has a choice between Section 703 exemptions and Section 704 exemptions. So let's take the latter for our purposes. Under Section 704 exemptions, you have home, vehicle, jewelry, tools of trade, retirement accounts, Social Security deposits in your bank account. So all of those are exempt properties. And there is an exemption limit attached to each. So let's talk about the home. So in California, under Section 704, the home equity exemption amount is $100,000 for married couples under 65 years of age, which means if you file bankruptcy and you have a home in which you have more than $100,000 in equity, then you risk losing that home. If you have less than $100,000 in equity in your home, then you will not lose your home in bankruptcy. It's the same thing for vehicles. In California, under Section 704, the car equity exemption limit is approximately $3,000. So if you have more than $3,000 of equity in your car and you file bankruptcy, then you may lose it in bankruptcy. If you have $3,000 or less in equity in your car, then you will get to keep your car in bankruptcy. Okay, and I'm going to have a separate video in which I delve into this topic in excruciating detail, and I'm going to have about half a dozen hypotheticals, and I will take you step by step through each hypothetical to determine whether you get to keep your car or your house. Okay, so be sure to look out for that. All right, I think that's enough for now. Let's go back to the Chapter 7 process. So just to summarize, the case trustee will identify your non-exempt assets, namely your secured properties that have positive equity, and your unsecured properties, and also your exempt assets that are over the exemption limit. And the trustee will proceed to seize these assets and sell them, and then use the sale proceeds to pay your unsecured creditors. Why unsecured creditors? Because the secured creditors are already protected by their collaterals, so the trustee is not worried about them. Remember what I said. The trustee's primary goal is to liquidate your non-exempt assets in a way that maximizes return for your unsecured creditors. Because after bankruptcy, all of those unsecured debts will go away, and those unsecured creditors will have no recourse to collect on those debts. All right, so let's move on. 20 to 40 days after filing, the trustee will hold a creditor meeting, otherwise known as a 341 meeting. And at the meeting, the trustee will put you under oath and then ask you questions about your assets and debts. And the creditors will also be present, if they choose to be, and will have a chance to ask you questions. 80 to 100 days after filing, you will have to complete a financial management course. And then, the moment we've been waiting for, 4 to 6 months after filing, the court will discharge your debts, which means those debts permanently go away. What does this mean for your unsecured debts? Well, this means your unsecured debts are erased forever. You no longer have to pay them. Okay, so they're gone. You don't have to worry about them. You don't have to worry about hearing from your unsecured creditors because they are prohibited by law from contacting you in any way. Okay. What about your secured debts? Well, they are also discharged in Chapter 7, which means you are no longer personally liable for your secured debts either. However, remember what I said about the collateral, which are there to guarantee the secured debts. So the secured creditors still have a lien on those collaterals, like your home or your car, and they can still exercise that right by foreclosing on your home or repossessing your car. So that danger remains after bankruptcy. And also remember, you are still responsible for those non-dischargeable debts because Chapter 7 does not erase them. That's why they are non-dischargeable. So these debts are back taxes, overdue alimony, unpaid child support. So after bankruptcy, you are still on the hook for those non-dischargeable debts. All right, so lastly, is there a limit to the number of times you can file Chapter 7? Well, the answer is a resounding yes. You can't keep filing Chapter 7 every time you want to get rid of a debt. So generally speaking, you can only file Chapter 7 if your last Chapter 7 or Chapter 11 filing was more than 8 years ago, and your last Chapter 13 filing was more than 6 years ago. If you are considering filing for bankruptcy, I wish you the best of luck. If you found this video helpful, then please give it a thumbs up. And if you haven't already, please subscribe to my channel. I have a lot more content coming your way about all kinds of interesting legal topics. Thank you for watching, and I'll see you next time. Goodbye.